And greetings, everyone. Welcome to another exciting edition of American Jurisprudence. This episode, Abuse of Process, Misused Purpose, and Civil Liability. We'll be assisted with Black's Law Dictionary, 9th edition. Just a moment here. Let's zoom this in a little bit more. And 9th edition Black's Law, and this will help us with any words that we come across that might be unfamiliar, and that way we will leave no word behind. And let's proceed. Oops. Okay, so we're going to be going into abuse of power, or abuse of process, and this is going to involve, just a moment here, let me get this zoomed in too. Let's see how it looks on the screen there. We get over here a little bit. There we go. Excellent. Yep, let's sharpen up those Esquire pencils, hit the like, and let's get started. So today we're going to be discussing abuse of process and the summary here. This article discusses civil liability for the misuse of a legal process in order to accomplish a purpose for which that purpose is not designed. So we'll be going over the federal aspects. The Fair Debt Collection Practices Act prohibits a debt collector from using any false, deceptive, or misleading representation or means in connection with the collection of any debt, including the representation or implication or threat that non-payment of any debt will result in the arrest or imprisonment of any person, or in any action that cannot legally be taken, or that is not intended to be taken. And then we'll look under the 2nd edition of American Jurisprudence, Consumer and Borrower Protection, but we're not going to look at that now. The Federal Tort Claims Act does not permit recovery against the United States on a claim of abuse of process. Against the United States. So those are the federal aspects of the abuse of process. And what we're going to be looking at more is some of the other issues regarding abuse of process. So let's get to it. The general considerations. Abuse of process may generally be defined as the use of a legal process, whether criminal or civil, against another primarily to accomplish a purpose for which the process was not designed. So it's generally defined as a legal process. It can be criminal or civil. And so we're using this legal process against another. And it's primarily, that means it needs to be mainly to accomplish a purpose for which the process was not designed. So we have purpose, we have process, right? We're looking at primary, right? Primary action and the use of that legal process. Abuse of process occurs when a person uses a legal process, whether criminal or civil, against another primarily to accomplish a purpose for which it was not designed. As we just read, you'll notice sometimes it seems redundant in American jurisprudence, but what we're doing here is we're citing it from another footnote here, number 4. This was number 3. So let's see what the difference is here. Oh, Lord. Okay, well, that's why. Number 4 is a very simple one, 2015, and footnote 3 is a whole bunch of cases from 2003 on. Tort of abuse of process occurs when a party has willfully misused criminal or civil process after it has issued in order to obtain a result not contemplated by law. Wow. So yeah, there's some interesting cases, but we're not going to read those today. I just wanted to clarify for the audience here and everyone watching why we would say basically the same thing twice, is that it was said again in another footnote here, another case or cases. In regard, The Restatement of Torts, second 2D, second edition, states that, now restatements is, remember, restatements of law, they're sometimes called. So these aren't necessarily laws, but they're ways of interpreting the laws so that they can adapt to the needs of life. So Restatement of Torts, second edition, states that one who uses a legal process, whether criminal or civil, against another, primarily to accomplish a purpose for which it was not designed, is subject to liability to the other for harm caused by the abuse of process. It has also been stated that the abuse of process is the misuse of legal process to accomplish some purpose outside the scope of the process itself. And that abuse of process occurs where someone attempts to achieve, through use of the court, that which the court is itself powerless to order. For example, a plaintiff's company filing of a lawsuit against another company in an attempt to settle its dispute with that company was not an abuse of process, as a plaintiff's action never requested the court to reach beyond its authority. So very interesting concept right there. Whenever you're thinking about lawsuits that are used to threaten others, that it's not the court that's doing the threatening. If there's no authority of the court to settle the dispute, then what is anyone worried about? The threat shouldn't be existing. So that's, I think, what this kind of stems at. In its most basic sense, an action for abuse of process is intended to prevent parties from using litigation to pursue objectives other than those claimed in the suit, such as using a court's process as a weapon to compel another party to pay a different debt, or take some action, or refrain from it. Thus, the essence of a cause of action for abuse of process is a perversion of the process to accomplish some improper purpose. Wow, beautiful words here. And before we go on, I just want to remind everyone that this is strictly for entertainment purposes, and we're just kind of going over this. I have no legal, lawful expertise whatsoever. None of this should be construed or interpreted as advice or legal advice or guidance in any way, shape, or form. And it's just here for your viewing, listening pleasure, and don't try this at home. Let's proceed. Because of its potential chilling effect on the right of access to courts, the tort of abuse of process is disfavored and must be narrowly or strictly construed in order to ensure the individual a fair opportunity to present the claim. So we can get into tort very detailed, but I think this is a good opportunity to hop on over to our friend Black, and let's look inside the dictionary here and see what Dr. Black has to say here. And we're going to look up tort. And that's going to be way down at the end here because it's a T. This thing finds every occurrence in it because it's a scanned document and it's not very organized. And just about there. Tort. And if everyone's there, if you can still hear me, if the audio is good, let me know in the chat. Because I'm not even sure. I'm broadcasting well to the interwebs here. There we go. 1654. Okay, here we go. Tort. 16th century. A civil wrong, other than breach of contract, for which a remedy may be obtained, usually in the form of damages. A breach of duty that the law imposes on persons who stand in a particular relation to one another. All right, so let's write this one down here. As we go to look for a simple little four-letter word, but we have this great quote, so we're going to read these quotes. To ask concerning any occurrence, is this a crime or is it a tort? Is, to borrow Sir James Stephen's apt illustration, no wiser than it would be to ask concerning a man, is he a father or a son? For he may well be both. Wow. We may define a tort as a civil wrong for which the remedy is a common law action for unliquidated damages, and which is not exclusively the breach of a contract or the breach of a trust or other merely equitable obligation. It might be possible to define a tort by enumerating the things that it is not. It is not a crime. It is not a breach of contract. It is not necessarily concerned with property rights or problems of government, but is the occupant of a large residuary field remaining if these are taken out of the law. But this again is illusory, and the conception of a sort of legal garbage can to hold what can be put nowhere else is of no help. In the first place, tort is a field which pervades the entire law and is so interlocked at every point with property, contract, and other accepted classifications that, as the student of law soon discovers, the categories are quite arbitrary. In the second, there is a central theme or basis or idea running through the cases of what are called torts, which, although difficult to put into words, does distinguish them in greater or less degree from other types of cases. Know if that's any clearer to you? Not to me. Let's read here. A business tort, a tort that impairs some aspect of an economic interest or business relationship and causes economic loss rather than property damage or bodily harm. Business torts include tortious interference with contractual relations. See, now a tort is not only a breach of contract, but it's tortious interference with contractual relations, intentional interference with prospective economic advantage, unfair business practices, misappropriation of trade secrets, and product disparagement. Libel and slander, antitrust, torts. So look at this. A business tort is that impairs some aspect of an economic interest or business relationship and causes economic loss. That's your tort, rather than property damage or bodily harm. So it's something that looks like interference, libel and slander. All that seems to fall into tort if there is, even if there's a contract involved. As long as it's not about breach of contract, exclusively? Breach of contract? Not exclusively. Okay, there we go. Constitutional tort, a violation of one's constitutional rights by a government officer. See, now we're reading here in tort that it's not violation of the problems of government. It's not necessarily concerned with problems of government. But then we have constitutional tort, 1966, a violation of one's constitutional rights by a government officer, redressable by civil action filed directly against the officer. A constitutional tort committed under color of state law, such as a civil rights violation, is actionable under 42 U.S.C. 1983, sometimes informally shortened to contort for constitutional tort, not contort. So that's something interesting there. So I think we get this: premarital tort, personal tort, negligent tort, mass tort, maritime tort within admiralty jurisdiction, marital tort, one spouse against the other. Since most jurisdictions have abolished interspousal tort immunity, courts have had to decide which tort claims are recognized between married persons. Oh boy. Intentional tort, government tort, a tort committed by the government through an employee, agent, or instrumentality under its control. The tort may or may not be actionable depending on whether the government is entitled to sovereign immunity. A tort action against the U.S. government is regulated by, the Federal Tort Claims Act. There you go. While state action is governed by the State Tort Claims Act. And municipal corporations. Okay, so we got some pretty cool stuff out of that. Everyone's still here? Great. Let's move along. So, the tort of abuse is disfavored. So because of its potential chilling effect on the right of access to the courts, the tort of abuse of process is disfavored. So they don't want lawsuits in tort over the abuse of process and must be narrowly or strictly construed to ensure the individual a fair opportunity to present the claim. And that's number 11, 12, 13, and 14. So nothing, no notes. All right. Is that it for this section here? Yeah. I saw something here from Florida Reporter. It's all right. We'll look this up later. So we were looking at this one earlier here. The tort of abuse of process occurs when a party has willfully misused criminal or civil process after it has issued in order to obtain a result not contemplated by law. Common law tort of abuse process under Pennsylvania law involves the perversion of the legal process after it has begun in order to achieve a result for which the process was not intended. A cause of action arises when the legal process is employed as a tactical weapon to coerce a desired result that is not the legitimate object of the process. Cool. Ooh, shoot. Just lost that one there. Hang on a second. I got to bring this back. What happened there? Jeez. Just a moment here. Gotta get right back in here. Use of processes. Come on, refresh. You know what's going on here? There, come on. Let me try one more thing here. Give me a hard time. All right, there we go. And let's continue. All right, so we had the three categories of process under Massachusetts law for purpose of claim abuse of process. One, these are your categories of process for claims of abuse. These are the three categories of process that can be abused. Writs of attachment can be abused. The process used to institute a civil action can be abused. And the process related to the bringing of criminal charges. So civil, criminal, and writs of attachment. Okay, and then what else we have here? Using legal process primarily to harass and cause direct injury to an adversary could constitute a perversion of that process as required to support a claim for abuse of process under Pennsylvania law. The essence of the cause of action for abuse of process is the misuse of the court's power, usually to compel the victim to yield on some matter not involved in the suit. So this is an interesting essence of the cause of action for abuse of process, is when the court's power is used to compel the victim to yield on some matter that is not involved in the lawsuit. So if the action that's being, or whatever matter that the victim has to yield on, so the victim has to give up on some matter that's not involved in the original lawsuit. And that would be the essence of your cause of action for the abuse of process lawsuit. going forward. Oh boy. Neurosurgery and spine surgery. That looks like a painful case there. All right. Definition of process. So what is process? We keep talking about process. In order to maintain an action for abuse of process, there must have been an issuance of legal or judicial process. It has to be an issuance. It has sometimes been said that the term process, as used in the tort of abusive process, is interpreted broadly and encompasses the entire range of activities and procedures incident to the litigation process, including discovery proceedings, notice of depositions, and issuing of subpoenas. So all these are considered process. It has also been stated that for the purposes of abusive process, process, quote unquote, refers to the papers issued by a court to bring a party or property within its jurisdiction, such as a writ of attachment, the process used to initiate a civil action, or the process related to the bringing of criminal charges. All right, so now we're at writ of attachment. We've got to find out what that means. So give us a moment here, and let's find out what writ of attachment means. Writ. And looking here, boy, there's a lot of them. Swearing contest, swearing match. It's actually a legal term. All right, it was writ of attachment, right? All right, this is close enough, 1777. Writ of attachment. Ah, geez, see attachment. Goodness, that's why I wouldn't find it. All right, one more time here. Let me find it. Attachment. Attachment appearance. There we go, 173. Okay. We got attach, the attachment. We center the screen enough. There we go. Okay. Attachment from the 14th century. The seizing of a person's property to secure a judgment or to be sold in satisfaction of a judgment. All right. But we were looking for a writ of attachment, right? So let's see if we can find that writ of attachment here. Oh, why don't I see it here? Did I pass it? Writ of attachment. Let's see something here. What happened? Oh, shit. Pardon me, let me just fix this here so it doesn't do that again to us. Okay. So, let's get back to where we were here. Almost there. Oh, okay. So, what we want to find has also been said, the process refers to papers issued by a court to bring a party or property within its jurisdiction, such as a writ of attachment. So again, let's get back to writ of attachment. Sometimes it's ridiculous trying to find this stuff here. Judgment, provisional attachment, ancillary. Bond, lien, earnings, risk, wages. All right, well, we got enough. I guess it's a writ of attachment. So we just look up attachment, which we did. So this should be enough. It's just a seizing of a person's property to secure a judgment or to be sold in satisfaction of a judgment. So it's the attachment is the seizing of a person's property to secure judgment, and a writ of attachment is the paper the court ordered to seize it. So something like, I guess, could be a lien, right? So let's move along. Okay, again, it's not an exact science. I'm not a law professor or anything like that, and I don't think anyone in the audience is, I hope, because they'd be really criticizing me otherwise. But I think it's an easy thing for us to all be able to do is to look into dictionaries and find things when we're not too sure. So at least we can be sure that we're reading it correctly. You know, it's kind of what I was reading the first time, but I wanted to be sure, and now I am. So let's proceed. So writ of attachment, the process used to initiate a civil action or the process related to the bringing of criminal charges. That is, process, the abuse of which may support an abuse of process claim, is not limited to the original pleadings, depositions, motions, interrogatories, and other requests for discovery, or legal maneuverings to compel or prohibit action by an opponent. All invoke the authority of the court and are therefore the type of process that will support an abusive process claim. Big talk here, because that's what we're saying here is that anything that the court is doing, right, may support an abusive process claim is not limited to the original pleadings, right? All types of process, like that, legal maneuverings to compel. So that's kind of an unclassified thing there. Hey, we got Justice Berserker in the house. Howdy. Yeah, we're going over abusive process right now. So a great topic for you to join us with. Hey, and Shockproof is here too. Excellent. All right, we got some people finally in the house here. So let's continue here. Yeah, it's been a little bit of a slow start. We're getting over the initial summary and going over some initial words is usually the slow start whenever we pull up a new topic. But now I think we're going to start moving. Okay, so we're pretty clear here that process, man, this thing's already giving me a hard time again. Just one more time. Oh, shit. Give me a moment. I got to refresh it. Yeah. I can't win. All right, there we go. Okay, so again, what we wanted to say is that the definition of process is the abuse of which may support, here it is. Legal maneuverings to compel or prohibit action by an opponent. That's another one too. That's a very broad one. And in addition to that, we have the standard things. You know, not just original pleadings, you know, like the depositions, motions, and interrogatories, other requests for discovery, and then these legal maneuverings to compel or prohibit action, all kinds of orders and such, right? By an opponent. By the opponent, right? All invoke the authority of the court and are therefore the type of process. So we're basically putting this in the species of processes that will support your claim for an abusive process. So interesting list. Let's look at this one last time before we move on. So of course we have your original pleadings. If those are not, those can be abused. You could have grounds if those are abused. Then you have the depositions, the statements people are made under oath, right? Motions, interrogatories, and other requests for discovery. So if they're mishandling requests for discovery, that could be cause of action for abuse of process. Legal maneuverings to compel action by the opponent or prohibit action by the opponent. So that's another thing that can be done. All kinds of intimidation tactics could be used and considered abuse of power, but they all must invoke the authority of the court. Okay, so let's move along. So we have a cumulative supplement here with some cases. And the institution of a civil action by summons and complaint is not legally considered process capable of being abused, as would be required for a claim of abuse of process. So the institution, so when you institute a civil action by summons or complaint, is not considered abuse of process. So by instituting a civil action, it's not, because it's not invoking any power of the court. Because if it's an invalid summons or invalid, by summons, civil action by summons and complaint. I got it. So, 2016. Wait a second. Let's look at this again. The institution of a civil action by summons and complaint is not legally considered process capable of being abused. Wow. So I guess when they just bring you into administrative court and they slip around, hey, silent auditor in the house. This looks like they're out for a traffic court here. That can be considered an abuse of power. Let's find out what it is. 2016. I'm sorry, it was footnote what? No, they just give the case here. Forget it. This is New York. So we have here, because the purpose of the tort of abuse of process is to preserve the integrity of the court, the tort requires misuse of a judicial process, and therefore it does not extend to misuse of administrative proceedings, even those involving agencies with quasi-judicial powers. Wow. Computer Express versus Jackson. That is California, 2001. Computer Express. Interesting. So because the purpose of the tort of abuse of powers is to preserve the integrity of the court, the tort requires misuse of judicial process. Therefore, does not extend to misuse of administrative proceedings. Oh, wow. So administrative proceedings won't affect the integrity of the court, I guess. Or quasi-judicial. All right, let's see what else we got here. Although the purposes of an abuse of process claim, the term process is not confined to the strict legal definition of the word. Process is still an act done under the authority of the court for the purpose of perpetrating an injustice, a perversion of the judicial process to the accomplishment of an improper purpose. So there we go. Let's see this one more time. And this was quasi-administration. That's what it comes down to now, right? That's more like it. Quasi-administration. Yeah, so process instead of proceedings. Understand this, that, let's look at this one more time, finally. Although for the purposes of an abuse of process claim, the term process is not confined to the strict legal definition of the word. So an abuse of process wouldn't have to be something that's, like service of process, something that's strictly the definition of the word. Process is still an act. So here's the definition by law, really, is an act done under the authority of the court for the purpose of perpetrating an injustice, the abuse of power, abuse of process, right? An example, a perversion of the judicial process to the accomplishment of an improper purpose. So that's an interesting one. That's Arizona, 2004, Connecticut. So that's another interesting one to look at there. And as we're seeing here, proceedings on our list here. Pleadings, deficits, and interrogatories, and other requests, legal maneuverings, and see proceedings on here. Now, the process, now we're looking in the context of process of abuse claims. So it's not limited to original pleadings, depositions, motions, interrogatories, and other requests for discoveries, or legal maneuverings that could be pleadings, but it has to be a legal maneuvering to compel or prohibit an action by an opponent, right? And they all have to invoke the authority of the court. And somehow it would have to support that abuse of process claim. All right, let's continue. Good question, though. Oh, here we go. Residential landlord's filing of a criminal complaint against a tenant, charging him with false swearing before a city rent leveling board constituted process. As an element of malicious abuse of process, the criminal complaint triggered a chain of events that summoned the tenant to appear in court under threat of arrest, to appear before a superior court judge, to be referred for processing at the county jail for fingerprinting and photographing for a mugshot, and then to await the determination of a grand jury after presentation of a criminal complaint to that body. Holy shit. And that was where? Massachusetts. 1980, though. Wow. Residential landlord's filing of a criminal complaint against a tenant, charging him with false swearing before a city rent leveling board constituted process. So he got him for malicious abuse of process. Wow. That's a mean landlord, huh? Distinctions from malicious prosecution and malicious use of process. Okay, big distinction here. Let's see here. We get to go into the trial strategies. And the great thing about American jurisprudence, there's just so many more great things in here. So this one's under proof of facts and then under trials. We'll get into these one of these days. The action for abusive process is similar to the action for malicious prosecution in that both actions are based on the imprudent use of the courts. However, they are indistinguishable in that malicious prosecution concerns maliciously or wrongfully causing process to issue, while abusive process concerns the improper use of process after it has been issued. Oh boy. So, malicious prosecution causing the process, whereas abuse of process is after it's been issued. Do you see this? So the malicious prosecution could be preemptive, whereas abuse of process is after you've been wronged. Moreover, abuse of process, unlike malicious prosecution, typically focuses on the actions of those prosecuting the case after legal process has been initiated. That is, after probable cause has been established. Ooh, okay. So abuse of powers is after the fact. Malicious prosecution could be during or such. It could be something more preventive, so to speak. All right, let's see here. The definition of the significant distinction between these two causes of action is that in the former, the wrongful act is the commencement of an action without legal justification. And in the latter, it is a subsequent proceedings, not in the issue of process, but in its abuse. In addition, malice and want of probable cause in procuring issuance of the process, as well as a termination favorable to the plaintiff, are essential to the maintenance of an action for malicious prosecution, but are generally deemed not essential to the maintenance of an action for abuse of process. So there we go. Malice and want of probable cause in procuring issuance of the process, right, are essential to the maintenance of an action for malicious prosecution. So this is something where you can. It looks like it's during the trial or such, or previous to the trial, where you'd be making motions regarding to the malicious prosecution, where as well as a termination favorable to the plaintiff, right, are essential to the maintenance of an action for the malicious prosecution, right? But these are not essential to the maintenance of an action for abuse of process because it's probably already terminated so far, at least as far as the process has gone. So the termination is going to have to occur before you can say the process has been abused, right? Termination, favorable to the plaintiff. And those are for malicious prosecution. Some jurisdictions use the term malicious prosecution when the process involved is criminal, and the term malicious use of process when the civil process is involved. Ooh. Malicious prosecution if it's criminal, and malicious use of process. And that's in some jurisdictions, so check your local state. All right, we get a little comment here from, let me read this one out because it doesn't quite fit. I charge the judge and prosecutor with judicial and prosecutorial misconduct in my federal appeal. Oh, in the appeal, huh? Okay, let's see here. Charge the judge and the prosecutor. Prosecutorial misconduct. So I'm not sure if that falls, that's after the fact. I mean, that looks like an abuse of power would be an appropriate cause of action you have here, a claim, I should say, for that, because look what this is after the fact. Appeals can take quite some time. This would be another case that you would initiate that would be basically about this one that's already here. I guess it could be done concurrently with the other one too. Make sure this is set up here right. Okay. Yeah, that's an interesting. I didn't realize you had that going on there. So if you have that case charging him with that, is it are you using anything like abuse of process within that? Is the question. But if you don't want to answer, that's fine too. But if you'd like to, you can. And we'll go on here to see where were we here. Why is it showing me? Oh, there we go. Okay. So some jurisdictions use the term malicious prosecution, again, and malicious use of process if it's civil. Under Maryland law, defendants counterclaim about the untoward purposes and methods employed by a distributor of pornographic movies in bringing suit against individuals who allegedly illegally downloaded such movies, sounded as one for malicious use of process rather than abuse of process. Abuse of process claims do not concern whether a complaint was brought or any court process was issued in good faith or based on sufficient cause. In other jurisdictions, these terms may be used interchangeably. Still in other jurisdictions, malicious prosecution, remember malicious prosecution is usually the criminal variant, is used to refer to actions involving both civil and criminal processes. So, go figure. And here we get a little example case here. Unlike a malicious prosecution action, an action for abuse of process does not necessarily require proof that the action was brought without probable cause, or that the action terminated in favor of the party alleging abuse of process. Does not necessarily require proof that the action was brought without probable cause. So an action could have been brought with probable cause, and the action could have been terminated in favor of the party that's bringing suit for abuse of process. So actually the result of the abuse isn't necessarily the crime itself or the civil claim itself. It seems like the abuse of process is in and of itself not determined by the outcome. That's pretty interesting there. So again, it's to preserve the integrity of the courts. So that makes sense. Lots of cases. Abuse of process, as distinguished from malicious prosecution, arises when a legal proceeding, although set in motion in proper form, becomes perverted to accomplish an ulterior or wrongful purpose for which it was not designed. That's in Rhode Island, 2002. As of particular elements of the tort of malicious prosecution, see AmJur. Oh, malicious prosecution, cool. Although each cause of action should be set forth in separate counts, the same facts can give rise to an action for abuse of process and malicious prosecution. Cool. They should be set forth in separate counts. The same facts can give rise to an action for both abuse of process and malicious prosecution. You miss a cue, you can still do it. It's never too late. We wanted to see, you said you charged the judge, and the question was, did you get him for abuse of power? Because I believe it was after the ruling. I mean, abuse of process, I'm sorry. Abuse of process. The tort of malicious abuse of process represents an attempt to strike a balance between the interest in protecting litigants' rights of access to the courts and the interest in protecting citizens from unfounded or illegitimate applications of the power of the state through misuse of the courts. And that's from Westar Mortgage Company, and that was 2001 in New Mexico. 2000, yeah, of course. All right, Donna, this one is an action for malicious prosecution is normally the remedy available to a party aggrieved by the wrongful institution of a civil, criminal, or administrative proceeding. So that's they want you malicious prosecution if it's part of the proceeding. Ah, you see this? Okay, cool. So here's your thing right here. Here's your case law to look up. This is DC 63. An action for malicious prosecution is normally the remedy available to a party aggrieved by the wrongful institution of a civil, criminal, or administrative proceeding. By the wrongful institution of. So let's look up institution to see what that really means. Off the screen there, and that way we can be sure that when we see institution, we have constitution, institution, and I don't think they mean the insane asylum either. So let's see what they mean by institution. A moment here to look it up. Man. Hard. Almost there. Hang in there with me. Geez. Okay, now we're getting close. Jeez. Okay. It's giving me a hard time to find it. Give me a second, I'll find it though. It's just in here so many times. Oh, goodness, jeez. All right. Sandwiches, there we go. 987. Okay. No, that's not the right page. 897. Okay. Institution. The 14th century. Nice old word here, huh? The commencement of something, such as a civil or criminal action. An elementary rule, principle, or practice. An established organization, especially one of public character, such as a facility for the treatment. Okay. Civil law. A testator's appointment of an heir. The designation of an institute. Okay, so all right, we got it here. Commencement of something, such as a civil or criminal action. Right. So what they're saying here is it's an action for malicious prosecution. It is normally, I'm on the right one? No, I need to switch back. Come on, get back. There we go. All right, there we are, correct on screen now. So an action for malicious prosecution is normally the remedy available to a party aggrieved by the wrongful institution. That's the bringing forth of the civil, criminal, or administrative proceeding. So there you go, proceeding. And there's your word too, proceeding. So what's a Black's Law? That's what we just looked up. What do you want to see a Black's Law dictionary definition of? I think, was it on the screen while I was reading it? Should be on the screen. Yeah, it should be on the screen. Yeah, there it goes. Okay. Yeah, institution, the commencement of something, such as a civil or criminal action. So that's when they're referring to the institution of a case, that's the starting of it. So there we go. Of your proceedings. So there you go. Let's move along. That's it. Oh, so you saw this William versus City Stores Company, and that's in the D.C. circa 1963. So we're on to distinction from false imprisonment. False imprisonment is the unlawful restraint by one person of the physical liberty of another, in contrast to an action for abuse of the process of arrest, which may be established only if it is shown that the process was misused in furtherance of an ulterior motive. The defendant's intention on purpose in detaining a purpose is immaterial to the maintenance of an action for false imprisonment. So false imprisonment, an action for abuse of process of arrest, because remember we're looking at abuse of process, and arrest is a process, the process of arrest, which may be established only if it is shown that, the process was misused in the furtherance of an ulterior motive, and that's Section 6. The defendant's intention on purpose in detaining a person is immaterial to the maintenance of an action for false imprisonment. So the defendant's intention or purpose in detaining a person, so their purpose is immaterial to the maintenance of the action. It's not their purpose of what the defendant did, I guess, to be the bad tyrant, right? Let me read this again here, because it's a long sentence. False imprisonment is the unlawful restraint by one person of the physical liberty of another. We got the definition. In contrast to an abuse. Okay, that's false imprisonment. So abuse of process of arrest. So now, in contrast, which may be established, talking about abuse of process of arrest, only if it is shown that the process was misused in the furtherance of an ulterior motive. The defendant's intention or purpose in detaining a person is immaterial to the it's so hard to read these sentences because they're written properly, but it's not a normal way of reading because they're written very succinctly too. In contrast to an action for the abuse. So okay, the defendant's intention and purpose in detaining is the maintenance of an action for false imprisonment. Okay. I guess it's getting late. So you guys see how this is divided up. So we're contrasting two things, compare, contrast. So it's an action for abuse of process is only if the process was misused in the furtherance of an ulterior motive. So there's a process of arresting and it was used for an ulterior motive. That could be an abusive process of arrest. To contrast that with false imprisonment, which would be the defendant's intention or purpose in detaining a person is immaterial to the maintenance of an action for that. So even if he didn't mean to do it, he didn't do it on purpose, the fact that he falsely imprisoned someone, then he could be liable for false imprisonment. But if he actually does it, abusive process of arrest is show that the process was misused, the arrest was misused in furtherance of an ulterior motive. So you have to prove an ulterior motive too. So the bar seems rather high for abuse of process of arrest. Nevertheless, if it happens, it seems like it'd be a very clear-cut deal. Maintenance. Yeah, so maintenance. You got it. We're going to find out what maintenance means in the legal terms. because, again, sometimes you get surprised by what you read. Hang on. Maintenance. All right. Man. Maintenance. There we go. Wait, that wasn't too bad. 1067. Oh. On blacks, right? Yep, there we are. 67. Okay. Maintenance. The continuation of something, such as a lawsuit. The continuing possession of something, such as property. I think we got it right there. Lawsuit. Continuation of a lawsuit. The continuation of it, so they can't terminate the lawsuit. All right, there we go. I feel smarter than the Esquires now. False imprisonment is the unlawful restraint by one person of the physical liberty of another. In contrast to an abuse of the process of arrest, which may be established only if it is shown that the process was misused in furtherance of an ulterior motive, the defendant's intention or purpose in detaining a person is immaterial to the maintenance of an action for false imprisonment. So property is too deep. We're not getting over property right now. That's for another. I was actually going to be diving down that rabbit hole where we'd be talking about some property issues. We'll save that for the deeds. All right. General requisites. In some jurisdictions, 3 elements are required to make a showing of the process. The defendant made an illegal and improper, perverted use of process, a use neither warranted nor authorized by the process. 2. The defendant had an ulterior or improper motive or purpose in exercising such illegal, perverted, or improper use of process. And 3. Damage resulted to the plaintiff from the irregularity. Stated otherwise, the elements of an abuse of process claim are 1. The improper use of the court's process. 2. Primarily for an ulterior or improper purpose. And 3. With resulting damage to the plaintiff, asserting misuse. Okay, that seems pretty clear there. All right, let's continue here. In other jurisdictions, 2 fundamental elements are generally recognized as constituting the basis of the tort of abuse of process. 1. A willful act in the use of process not proper in the regular conduct or prosecution of the proceedings. And 2. An ulterior motive or purpose on the part of the person causing the process to issue. So here we go. Willful act. These are in other jurisdictions. So the different jurisdictions look at different things. There's only 2 fundamental elements. So buyer beware wherever you happen to be have your jurisdiction. No liability for abuses of process is incurred where the defendant has done nothing more than pursue a lawsuit to its authorized conclusion, regardless of how evil the defendant's motive or intentions might be. Oh gosh, evil. Number 4, who's being called evil? Well, a few improper use element of an abusive process claim is not met if the defendant has done nothing more than carry out the process to its authorized conclusion, even though with bad intentions. And that's Marlin Oil Corp versus Barbie Energy Corp, and that was Oklahoma. Okay, pretty interesting stuff there. So There we get the two different ones there, right? No liability. No matter how evil. The willful act of an abusive process claim can be understood as an obligation imposed on the complaining party to allege that the tortfeasor has confirmed, through the tortfeasor's conduct, an improper ulterior motive for employing legal process against the plaintiff. Yeah, they are. Some can be really evil. So you all know what tortfeasor means, or do you want me to look that one up? I think everyone knows what tortfeasor means, right? I do, but we're going to look it up because it's a fun word to look up. There's all kinds of feasors and assessors. Let's see, tortfeasor. Oh no, I knew it was coming. Shit. Come on. You know what? Why? So I said perverted. I think that's all it takes to trigger these things. Let's just report this guy too. It's just crazy. All right. So let's get back to tortfeasors. There we go, tortfeasor. What was that? 1655. Oh, well, I hit that thing by accident, huh? Shit. That's funny as shit. I can't win, huh? I was just timing it out, and I guess it somehow ended up popping up on the screen. Oh, boy. All right, give me a second here. Let's get back to blacks. I forgot my page. 1655. Okay. Tortfeasor. Hey, did we pass it? Yeah, we did. There it is. Tortfeasor. One who commits a tort or a wrongdoer. Hey, Disciple of the Messiah 1 is here. Perfect timing. All right. So the tortfeasor is one who commits a tort, a wrongdoer. There's all kinds of tortfeasors. Look at some of the tortfeasors we got. Concurrent tortfeasors, two or more tortfeasors whose simultaneous actions cause injury to a third party. Such tortfeasors are jointly and severally liable. Cool. There's consecutive tortfeasors, two or more tortfeasors. There's joint tortfeasors, successive tortfeasors. Okay, so we got all kinds of tortfeasors. Wrongdoers. Okay, so the willful act element of an abuse of process claim can be understood as an obligation imposed on the complaining party. Right? This is the obligation imposed on the complaining party to allege that the tortfeasor, the wrongdoer, has confirmed through the tortfeasor's conduct an improper ulterior motive. So the wrongdoer is confirmed through their conduct the ulterior motive, or an improper ulterior motive, for employing a legal process against a plaintiff. So you get all those things here? So legal, this is strictly legal, and acts good distinction here. The reason why is because what we're talking about here is abuse of legal process. So this strictly applies to when we're using legal process to what would you say, to enforce the law? Is how we enforce the laws through our legal system, right? So the legal system has to be aligned with the law. And we have a lot of ways of trying to keep it in balance that way. And that's what the courts of common law are supposed to do. That's what we're studying right here is American jurisprudence, because this is our version of common law here in America, which is combined elements of common law mixed in with our statutory garbage and such, but in a way that allows a superiority of our constitutional rights to, we have that supremacy of law where you can't have laws that would be, repugnant to our Constitution and the higher laws. So down the way, we have enough checks and balances, and our last check and balance is really through these courts. And if we don't understand or know how to exercise our common law rights, they're very quickly trying to destroy our common law abilities through these courts, through various means, through the bars, through the judges, through poor education, through the legal educational system that students are now getting, that's devoid of principles of common law and law in general, and it's become strictly administrative, procedural, the wrong type of direction for such a developed legal system, such as American jurisprudence, to be perverted into. And that's why something like abusive process is focused on correcting the legal system. Mostly the laws aren't that bad. The problem is these people that are perverting it through a misuse of the legal system, and being able to identify it and articulate it and express it in this way is a way that we can cause action to make change through that system. That's right at the source. So if we can at least make small motions and do we call a cybernetic approach, right? Small movements to keep us heading in the right direction, we might be able to retain this style of justice for future generations and posterity. Otherwise, we might as well just hand the keys over to the bar because they're waiting for it and they're working hard to get it fully in their control. And as long as we avoid learning what we're learning here tonight, they'll have it. So I really salute everybody that's here learning with me tonight on this, because to me this is one of the most important parts of retaining the great parts of America that we have. So legal. Well, when you get to legal person stuff is a whole other aspect too. The whole point here is to get the make sure that the institution of justice is functioning according to the law, and not just for the people that are operating it, which is the way the bar, the judges, the public servants, the public officers and such. Abuse of power seems to be a rampant. Abuse of process is the way we can articulate that to be a cause of action, to make claims and make change and get remedy. So this is going to be person versus people is a whole nother issue too. But we, the people, are the ones that control these courts. So collectively, the sovereign, the people, and each person is just as powerful as 2 or 5 or 1,000. So really, when we say one is harmed, we're all harmed. And that's why you can bring a criminal action, even if you personally aren't harmed, for an abusive process, because that abusive process is harming the integrity of our justice system in general and the courts. They're our courts. So anything that's going to destroy the integrity or harm the integrity of something that's our possession, we're the beneficiaries of these courts. And the people, the judges, everyone else in there are merely administrators of our property, which are the courts. So they're trustees, and we are the beneficiaries. Now, there's a certain arrangement for it to work well, but and the purpose of the laws, what Disciple of the Messiah is saying here is correct. The people are living. Person is a dead entity in some cases, and depending how it's defined. Sometimes there's an overlap that a person could be the living people too. A man or woman could be a person. Individual is another one. It's an individual, but is a guardian, and the one the guardian is responsible for could be considered one individual in the eyes of the court. So it's an interesting definition to look at. But I like to step back and look at the law and the purpose and the intent of the law. And the intent of the law is so that this legal system, when we're enforcing these laws, that they're not so rigid that they can't adapt to the needs of the living. So we always have to look to the intent of the laws. Is it serving the needs of the living, or is it serving the dead entities? And that's the difference between the law and the legal. If the legal is not aligned with what the law says, then we have an abuse of process. So that's kind of what we're getting into. If you notice, everything here is talking about intent, the ulterior motives. So we're not talking about a violation of a code. Even some of the things that are written, the fact that they're violated puts the perpetrator, at risk of being, on trial for abuse of process. So again, this is an important concept to understand, that there is a lot of ways to approach this. The most important thing is to have a clear understanding of how it's working, so that when they try to abuse the process, you can understand where it's happening and point it out and be able to articulate it as a cause of action to bring a claim and get correction. So, let's move along here. So we got a nice little cumulative supplement here. In order to prevail on a claim for abuse of process under Ohio law, a plaintiff must demonstrate, 1, that a legal proceeding has been set in motion in proper form and with probable cause. So the abuse of process, we first have to make sure it's been set in motion with probable cause. So false imprisonment without probable cause means you couldn't have an abusive process case as well. 2, that the proceeding has been perverted in order to attempt to accomplish an ulterior purpose for which it was not designed. And 3, that damages resulted directly from the wrongful use of process. So that's in Ohio. Notice how we're referring to U.S. Constitutional Amendment 4. So, again, this stuff is getting into Fourth Amendment rights. Protected rights, I should say. The elements of an abusive process claim are, okay, so we just read this, and that's in Arizona. Were to prevail, okay, same thing here. This is the Arkansas. So 3 points, 2 points, 3 points. Depends on how many elements, depends on your jurisdiction. The improper use element of an abuse of process claim is not met if the defendant has done nothing more than carry out the process to its authorized conclusion, even with bad intentions. So we read that one already. Okay, good. Good stuff. Ulterior motive or purpose. So how do we figure this out? We came up, this was a reference earlier for Section 6, and we're here. The ulterior motive or purpose generally required in an abusive process action may take the form of coercion to obtain a collateral advantage not properly involved in the proceeding itself, such as the surrender of property or the payment of money by the use of process. Is Deborah still here? As a threat or a club. There is, in other words, a form of extortion. However, mere ill will or spite towards the adverse party in a proceeding does not constitute an ulterior or improper motive, where the process is used only for the purpose for which it was designed and intended. Neither retaliation nor a malicious motive is sufficient collateral objective to satisfy a cognizable claim for abuses of process. Rather, an ulterior process or objective in facilitating the prosecution is required. So there you go. A retaliation or malicious motive is not sufficient collateral objective to satisfy a cognizable claim. So remember, we have a pretty high bar here to make a claim for what we were saying here was ulterior motive or purpose, right? That's motive, purpose of somebody, subjective. It makes it very hard to prove. So here are the things that are required here, though. We can see here. See, retaliation or malicious motive isn't enough for a cognizable claim. It's going to be an ulterior purpose or objective in facilitating the prosecution is required. The ulterior purpose element of an abusive process claim is not satisfied merely by showing that the person commenced litigation knowing it was groundless, nor is it satisfied by showing that the defendant acted with an improper motive of vexation, harassment, or annoyance. Rather, the ulterior purpose must be to gain some collateral advantage in that the defendant has allegedly tried to extract some advantage by wrongful means. So, you can see it's pretty complicated for that ulterior motive aspect. Not just by showing the person commenced it knowing it was groundless. That's not going to work for abuse of process. So the purpose was to gain a collateral advantage, and that defendant has allegedly tried to extract some advantage by wrongful means. So there it is. And here's the cases. Nice here. Filing of wrongful foreclosure lawsuit with a motive to delay or prevent the completion of the defendant's foreclosure constituted an abuse of the judicial process. Jackson versus Bank of America, 11th. Wow, that's in Florida, 2018. Filing of wrongful foreclosure lawsuit with the motive to delay or prevent the completion of defendant's foreclosure. Abuse. Yeah, that's pretty, it sounds like there might have been some details to that case there. I remember this case, Jackson versus Bank of America. Limited Liability Company, LLC manager's allegation that the member sued him to obtain something that the manager would not give him and to which he was not entitled, failed to state claim for abuse of process under Kentucky law. Even if the manager's characterization of member's motive was correct, it did not constitute abuse of process, as member used civil process for the purpose for which it was intended. So it meant if they stay within the purpose of, even if they're being really hard, as long as they don't do something wrong in the process, it's not an abuse of process. So yeah, under North Carolina law, so we're getting some examples here. Employer did not commit tort of abuse of process when it filed suit against its former employee and his current employer for breach of contract, computer trespass, misappropriation of trade secrets, unfair and deceptive trade practices, conversion, and civil conspiracy, despite employees' contentions that employer used suit to coerce him into executing non-compete agreement and or non-solicitation agreement ex post facto. Absent allegation that the employer continued some willful act not proper in proceedings regular prosecution. Ugh, Jesus. So we all remember what ex post facto was, right? Because we're all good on our Latin. After the fact, right? Let's see what it means in the exact. Man, everything takes a long time to find this thing here. All right, here we go. Oh, shoot. $6.89. Yeah, after the fact. I know it is. Having retroactive force or effect. That's what I wanted to get. I knew there was something else to it. Ex post facto means having retroactive force or effect. Literally, yeah, done or made after the fact. But in legal terms here, we need to know this. After the fact, retroactively. So retroactively, done or made after the fact. So retroactive is our key word for that. Oh, shoot, get back here. Okay. Absent allegation. Okay, so ever committed some willful act not proper in proceedings, regular prosecution. So did not commit tort abuse. Yeah, okay, so there's a non-compete in North Carolina. Yeah, they, in 2015, yeah, North Carolina's not a good state for that. Florida's a right-to-work state. Good luck with those suits here. We're Chapter 11 debtor, the owner and operator of a farming and outdoor equipment dealership that had sold 3 tractors and items of farm equipment to buyer, was found to have engaged in abusive process under North Carolina law by using the threat of its order of attachment and temporary restraining order. Remember, order of attachment and temporary restraining order, not to put the tractors and equipment in the sheriff's possession until a judge could rule on the merits of its prepetition complaint against the buyers and others, but to secure payment from defendants. Debtor could not use either the doctrine or First Amendment as a shield from liability. Both those defenses. That sounds like a complicated case here. Yeah. Right. Yes, there's some pretty good ones. GMC trucks. Order to state claim abuse process. Okay, so we've read that one. Yeah, these are all same things we already read. Sometimes they have extra little notes here. So here's where a lawful end is pursued by appropriate process. Incidental motives of spite or greed are not actionable pursuant to an abusive process claim. So there it goes. Then we get to injury and or damages. Although in some jurisdictions a cause of action for abusive process may be sustained despite the fact that there has been no seizure of the plaintiff's person or property, or that the coercion attempted by the improper use of process was unsuccessful, other jurisdictions require that a plaintiff bringing a claim for abusive process plead and prove that injury or damages resulted from the irregularity of process. Now, the only thing I remember reading before was that an abusive process doesn't necessarily require, well, injury or damages to the person bringing the claim. Didn't say that. It's such jurisdictions. Okay, some jurisdictions. Got it. In such jurisdictions, mere vexation or harassment are not sufficient losses to give rise to the tort. So let's see what don't sound like good jurisdictions. Arizona, South Carolina, Kansas, Maryland, Mississippi. Let's see here. Father's damage from being mistakenly arrested for an offense committed by his son did not result from a supermarket's filing charges that the son wrote an insufficient funds check, and thus the father could not recover against the supermarket. Oh, wow. Rather, the father's damages result from mistakes made by the district court's clerk office in acting on the supermarket's correct information. Iowa. Wow. Absent any evidence of damages to a father resulting from the failure of county attorneys to dismiss a child in need of care proceeding regarding the father's alleged abuse of his minor child or any ulterior motive on the part of his wife's divorce attorney. Wow, well, now I'm going to read this. Okay. You can read that case if you want. That's in North Dakota. Oh, here, a real estate developer. I'm sorry, that was Kansas, the other one. This one's a real estate developer could not recover against an excavation company for abusive process based upon the excavation company's filing of a mechanic's lien for 5 times more than it was entitled to be paid under a contract where the developer suffered no damages as a result to the abusive process. Okay. Makes sense. And there's malice. While in some jurisdictions, malice is not a necessary element of the tort of abuse process, except where punitive or exemplary damages are sought. Punitive or exemplary damages. It's not a necessary element, except where punitive or exemplary damages are thought. Malice, punitive or exemplary damages. Think of this. Some jurisdictions, It's not a necessary element, but some are. Proof of malice, whether actual or implied, is required in order to sustain a claim for abuse of process. Interesting concept, because you need to know your jurisdiction. Is malice a necessary element? And then proof of malice, so that raises the bar as to what constitutes, and that's California. Good luck. All right. Want of probable cause. This is a great one. Generally, want of probable cause need not be established in order to state a claim for abuse of process. However, facts tending to show that a person commencing the litigation knew or had reason to know that the claim was groundless are relevant to show that the process was used for an ulterior purpose. Yes, charges have elements. Everything is broken down to elements. Think of it like almost like a checklist you go through for this stuff to really get it right. So yeah, you definitely want to be aware of that stuff. Okay. Termination proceeding in which process is used. So, although the common law rule is that an action for abuses of process may not be instituted by a party who has not been absolved of guilt, favorable termination of prior proceedings is not an element of a cause of action for abuse of process. So, who has been absolved of guilt. So if you're left with guilt, you can show for abuse of process, which is kind of interesting. Favorable termination of prior proceedings is not an element of a cause of action for abuse of process. Thus, it is not ordinarily necessary to establish that the original action in which the process issued has terminated in favor of the plaintiff. While abuses of process claims do not include favorable termination as an essential element, the cause of action is still considered premature until the underlying litigation has been completed. So there it is. They do not include favorable termination as an essential element. Hear this? Cause of action is still considered premature while the underlying litigation is completed. So you kind of wait till the litigation is terminated for a abuse of process claim. Further holding that impunging of prior proceedings is not one of the consequences of an action for abuse. All right. And next section here is, miss it? No. So research references. And then we have the institution and prosecution of civil action. And this section here, we're going to go over abuse of process. Yeah. So this is a good place we're going to leave off, because this is where we're going to start for the next time on section 11, because we covered the first 10 sections and we're getting an hour and a half into it. I really like to keep people on the same page here, so to speak, for the whole presentation. So it's really nice that we can get this much done on it. Let's see what we're going to be looking at on the next section here for section 11, and then on to misuse and discovery on deposition procedures. So now we're going to get into more technical aspects of the cases, and that's good because we have a very strong foundation now from the first 10 sections that we went over today. So this is where we're going to be taking off next time, is the and again, we're looking at the February 2022 update. So this is rather current as far as the case laws we're pulling here. They're rather recent. And I don't know if that's not going to be in this edition, because this came out in February. So that came afterwards. So that would be something to look up in a supplement. I could try to find out if there's anything issued on that case there. But this is on page. So let's see where I am. And section 11 of prosecution. Great. Courts of equity and trust law. Yeah, I did a whole bunch on trust, and we should keep going on the trust because the trust is long. I think I did 3 or 4 parts on trust already, if I'm not mistaken. But there's more to go. Trust keeps going, and it keeps getting better, actually. So if you'd like Disciple of the Messiah, if you look at the previous ones I have on trust are really good, and the ones coming up, they should be just as good, if not better. But having that basic foundation of understanding what the trust is and the purpose of the trust and how it differs from other things like contracts and such is really what it focused on. So in a practical sense, you get a broad understanding of the intention of trusts. And from there, we can find out the different species and types of trusts and the purposes for those. Because, when it comes down to it, the trust is a great way for us to preserve property by keeping it distributed through various people and having the title divided between equitable and civil means. Yeah, please go check those out, and then and we'll plan on. Some of this stuff is kind of getting into the Social Security stuff, but I don't want to get too much into the weeds because one of the things I think is the biggest deficiency, is really learning more about the whole system of American jurisprudence that we have, because it's truly has been the strength of our nation. And as we're starting to see this liberal takeover of our judges and such, that we're seeing the common law being perverted to the point where it's actually becoming a weakness of our nation. As you'll see, some of these rulings that I pull up here are just terrible. Of what these judges are trying to do now. It's we get a question for Justice Berserker. If you'd like to throw something up, or you can always find out from her YouTube channel. But yeah, it's you definitely want to check this stuff out. Again, what I'd like to do is just to make sure everybody has a broad understanding of what our courts are supposed to provide for us to protect our liberties, and that to understand that the meaning and the intent of these laws is really to be focused on the needs of the living and not the needs of these corporations and the government and other things. So the most important thing is to focus on the living, and the law is focused on that, and its intent is to be adapted to the needs of the living and the life, so that we can all live in liberty and advance our culture in the way of expanding personal liberties. So now you have 3 cases and 3 courts. You might want to lay some of that stuff out. I got to check out your YouTube channel too. Do you want me to post it here in the chat? Which one is it? The Justice Berserker or the Deborah Rogers? Yeah, great. Thanks. Yeah, Spike, if that's working good. I was hoping it would work out well like that. I plan someday to index them all and have like a table of contents with timestamps so you can get to relevant sections, because they are quite long, but there are sections in them that are really just like little gems. Yeah, the subconsciousness. This stuff needs to get into our subconscious, because that's how we're going to be able to really spit it out when we need to, and when you're in front of them. That's kind of the key. Let's see here. Try to look on see Deborah's channel here so I can put it up for you guys. Give me just a moment here while I look. I have here my subscriptions here. Huh. I don't see it here. What happened? All right. Well, I was subscribed there. What the heck? Okay, so let me just give a moment here. Let me find out. Is it Just as Berserker. Okay, let me get it up here because I can put it in the chat for you. Actually, I think anyone can type it in the chat if it's a YouTube channel. Berserker. So Berserkers were the original lawyers, weren't they? And there it is. I know I subscribed. It must have unsubscribed me. Oh, God bless that YouTube. All right, there we go. And let me get back to us. And let me post it here in our chat. And there it is. So it's down there in the chat for you guys to click on. That should be the right one, right? Okay, so Berserker is from Ireland. I thought it was the I thought it was like Icelandic. The Berserkers. Weren't the Berserkers the ones where you had a dispute? Instead of going and fight someone yourself, you'd hire a Berserker, and they go and they'd beat up the other guy, and or the other guy would hire his Berserker, and then your two Berserkers would go and duke it out. Kind of like what lawyers do, a hired fighter in a way. I thought that's what the Berserkers were. I could be wrong, but it's nice to think of them that way. At least it makes me laugh. So on that note, yeah, I'd like to thank you all for coming on the stream tonight. It's been, again, as always, a delight to find out more information about things of the power that we have. This is the people's power. And by knowing this information here, this is where the rubber meets the road, where the knowledge does become power, when we can actually use it in action. So let's see, we got some other good advice up here on the screen. Name change, you could be recognized as adults. So you do the adult name change, you're not considered a minority any longer. Yeah. So yeah, there's that. There's a lot of aspects too that we could get even deeper into, or grown up, when it comes down to these kinds of things. I'm wondering about what the audience is looking at, if we should do more stuff involving property, titles, deeds, trusts, and such, or other things involving legal process and the rights and the way the government officials are doing, working in the public trust or not. Because knowing these things are really what help us identify the misuse and the abuses. And that allows us to bring these causes of actions to the courts where this is a proper venue, they need to be heard. We can complain if they're not being heard in these courts, but if we're not taking our due diligence to make sure they're pushed through, then we're not really using all of our power. So my goal of this is really to get the power back to the people so we stop giving it away to the bar, and take back our courts and bring back the common law and the American jurisprudence so that posterity can have the liberties that were promised to us and a lot of other people did sacrifice for. So this is supposed to be our sacrifice. It's only one of a mental struggle, so it shouldn't be too hard. And this way we can prevail. Again, I would like to thank everyone for showing up. I'm glad that Deborah made it, and I think we're going to continue learning more in this. If you like, I'll do another chapter for titles again. Trusts again, and work on that. We can also hit into titles. I have a lot on titles and deeds and such, and property. So if people are interested in property, I could also go into that, but I don't want to go too far into that if people aren't interested in dealing with that. But I will do another one on trusts because I don't want to leave that unfinished. I believe everyone should be using trust. I also have another great one on private membership associations, clubs, associations. That one's a really good one. And another aspect of organization that Americans need to be aware of. On that note, I would like to thank again everyone for showing up. And I would like to see you all subscribe and hit that notification bell so that you'll be notified when we do this again. And I will see you all on the next one. Peace out.